Hello and welcome to the Blackstone Solicitors channel. Today, we're talking about an important topic for anyone considering a professional negligence claim: the limitation period. Understanding this is crucial because missing the deadline can mean losing your right to take legal action entirely. Professional negligence claims arise when a professional, such as a solicitor, accountant, or surveyor, fails to provide the standard of care expected, resulting in financial loss or other harm. But while you may have a valid claim, the law sets strict time limits within which it must be brought. So, what exactly is a limitation period? In simple terms, it's the time frame set by law in which you must issue a claim. In England, the general rule under the Limitation Act 1980 is 6 years from the date the Negligent Act occurred. That might sound straightforward, but there are important nuances. For example, if the negligence isn't immediately apparent, perhaps a mistake in a property transaction or an error in financial advice that only comes to light years later, the clock may start ticking from the date you became aware, or could reasonably have become aware, of the loss. This is sometimes referred to as the date of knowledge. In most cases, there is also an ultimate deadline of 15 years from the act itself, even if the problem was discovered later. Let's look at an example. Suppose you instructed a solicitor to handle the purchase of a commercial property, but they missed a crucial restriction in the title deeds. You only discover this issue 3 years later when you attempt to develop the property. In this case, the limitation period might start from the date you discovered the problem, not the date the solicitor acted negligently. However, you would still need to act before 6 years have passed from that date, or before 15 years from the original act, whichever comes first. It's also important to note that limitation periods are strictly enforced by the courts. If you attempt to bring a claim outside the allowable time frame, the court may refuse to hear your case, regardless of how strong your claim might be. That's why acting promptly and seeking legal advice early is so critical. At Blackstone Solicitors, we regularly advise clients on professional negligence claims and the relevant limitation periods. We carefully assess the timeline of events, gather evidence, and determine the most effective strategy to ensure claims are issued within the legal timeframe. Missing a critical deadline can jeopardize an entire case, so understanding limitation periods is as important as the substance of the claim itself. Even if you're unsure when the negligence occurred, or when you became aware of the loss, it's best to contact a solicitor as soon as possible. Legal experts can help preserve your rights, investigate potential claims, and guide you through the process efficiently. It's also worth noting that limitation periods can differ slightly depending on the type of professional and the nature of the negligence. Solicitors, accountants, architects, and surveyors all operate under slightly different rules in certain circumstances, making expert legal advice essential to avoid mistakes. In summary, the professional negligence limitation period is a legal timeframe within which a claim must be made. It's typically 6 years from the act or omission, but it may start from the date you became aware of the loss. There is also a maximum 15-year period in most cases. Understanding and acting within these deadlines is essential to protect your right to pursue a claim. At Blackstone Solicitors, we provide expert guidance on professional negligence claims, including careful analysis of limitation periods to ensure your case is not compromised. If you believe you may have a claim or simply want advice on your options, contact our team today. If you found this video helpful, please like and subscribe to our channel for more legal insights from Blackstone Solicitors. Thanks for watching, and we'll see you in the next video.